class actions, insurance doesn't cover the class actions. What can you do to protect yourself on the class action front? We're getting some really good case law out of the U.S. Supreme Court where you can have these arbitration agreements where you agree with the employees not to go to court, but you hire a private former judge or an attorney to do a private trial, basically, in a conference room. And you can go to arbitration, and in these agreements, you can have the employees waive any class action rights. So it's a big advantage for large employers, and I think every large employer should at least consider these, if not implement them. In California, we have this Private Attorney General's Act claim, a representative claim. It's kind of like a class action, but it's kind of not. It's a hybrid under California law. The plaintiff's bar argues you can't waive these rights to bring a PAGA claim. We've been making the argument you can. The court's a little split on that. But these class action waivers won't protect you on everything. There's still an argument that these PAGA claims could still proceed. But I'd much rather be defending a PAGA case than a class action. There's only a 1-year statute of limitations on a PAGA case as opposed to a 4-year statute of limitations on a class action. So right there, you only have 25% of your liability. And you have some other arguments with defending those PAGA claims. So if you don't have an arbitration agreement in place, you should think about that. For smaller employers, if you're under 25 employees, it's a toss-up whether you want to do it. There's some extra costs with that. The employer also has to pay 100% of the arbitrator's fees, which can be a lot. So I think for large employers, it's a no-brainer. The smaller you get, you kind of have to think about it.